Hi, I'm attorney Eric Lewis with Lewis Legal Services in Indianapolis. Today I have a quick video to talk about a recent change made to the Indiana law in the landlord-tenant code. And it's a pretty big deal for anyone who's had a past eviction haunt them in getting a new lease. You'll be interested in what this new law does. So House Enrolled Act 1214 was signed by the governor on March 18th, 2022. And it goes into effect as of July 1st, 2022. The new law makes some changes to a few things, including making rental assistance funds more accessible to landlords, establishing a residential eviction diversion program, and just generally improving the dismissal process to clear the dockets of cases that just get filed and nothing is done. But what I want to talk to you about is the new chapter that adds the landlord-tenant code regarding expungements of evictions from public records. So now in my bankruptcy work, I have heard from many clients over the years that have had a lot of trouble getting someone to rent to them because of evictions that show on background checks and public record searches. And the real problem has always been that some of these cases weren't really even evictions. What would happen is that a tenant would miss a payment, a rent payment on the first of the month, and some of these apartment complexes would file an eviction lawsuit within a matter of days. The tenant would pay the rent plus the court filing fee and probably some type of attorney fee just a few days after that, and then the case would be dismissed without anyone ever going to court. So the problem was that once the case was filed in the court, it would show up as an eviction. And unlike a lot of criminal case matters that could be removed after several years or after doing some kind of rehabilitation, there was no way to remove civil cases like this from public access. So, for example, I had a lady come in one time. We pulled her lawsuit information on a background check, and I found that she had 10 evictions from the same apartment complex, which really didn't make any sense. And as it turned out, she just had trouble paying her rent at the first of the month because of the way her pay cycle was at work. And she would repeatedly have to pay late after an eviction was filed. The cases were all dismissed. She was never evicted, but they show up on public records as evictions. Okay, so now as of July 1st, 2022, these new chapters 10 and 11 have been added to the landlord-tenant code, which of course is Indiana Code Title 32, Article 31, Chapters 10 and 11. So Chapter 10 allows the judge, without anyone even filing a motion, to dismiss and seal a case from public records if no effort has been taken by the plaintiff to move forward on the case within 180 days of the eviction being filed. If the landlord doesn't proceed with the eviction and doesn't file a motion to dismiss the case within 180 days, the court can assess them a $10 fee against them for the court having to dismiss the case on its own. So I found that part funny, $10, that big deal. But under the new Chapter 11, the law lays out a new process by which a tenant can file a motion with the court to have the case restricted from public access if the case was dismissed or a judgment was entered in favor of the defendant. So this expungement process does not apply to cases where the landlord filed an eviction and the landlord was awarded money damages, which would be awarded for something like the tenant breaking the lease or causing actual physical damage to the rental property. So as I read and understand this new chapter, even if the tenant is actually evicted from the property, if the landlord does not pursue the tenant for any damages, then the expungement is still available. And in my experience, a lot of the time, even when landlords can collect damages in court, they often don't because they just want possession of the rental unit. They want the tenant out, and they don't care to spend more money chasing a tenant for damages and money. So eviction proceedings in a lot of courts, and I know this is the case for all the township courts in Marion County, are bifurcated into two proceedings. So the first proceeding is for possession of the rental unit. If the landlord is given possession, then they have the choice to proceed to a second proceeding, which is basically a trial on the breach of the lease agreement. So if they proceed with that and they win, they're awarded money judgment for whatever damages were done. So we're talking about either physical damages or just monetary loss for the breach of the lease agreement. Now, a lot of evictions do result in money judgments, and those would not be eligible for expungement. But in cases where there was either no eviction at all or the eviction does not result in a money judgment, this new law will be very helpful for tenants to clean up their records and get a second chance at getting a new residential lease in the future without having a lot of problems. I've told my clients for years that there was no way to expunge these records from public access, and now that's about to change. So for once, it looks like the people in the General Assembly have finally listened to me. So that's it for today. Leave a comment below. If you like the video, click like, subscribe for future videos, and as always, thanks for watching.